quorum call.
Without objection.
29 years ago today, 29 years ago today, President Bill Clinton signed into law a bill sponsored by then Representative Chuck Schumer, who aided in the defense and protection of one of the most fundamental freedoms that we have in our nation. That freedom, religious freedom. The bill was called the Religious Freedom Restoration Act. The Religious Freedom Restoration Act, passed by Congress today, 29 years ago, found that government should not substantially burden religious exercise without a compelling justification. It was truly a landmark piece of legislation to be able to add further protections to individuals that have religious liberty differences, and we have wide variations of religious expressions in the United States. It's part of what makes us such a unique nation, is that we guard the rights of every individual to not have to believe the same as the government believes, or not even have to believe the same as your next door neighbor believes, but to have the right to freely have a faith of your choosing, change your faith at any point if you choose to, or to have no faith at all and be respected as an American, and quite frankly, to be protected as an American. This landmark piece of legislation, the Religious Freedom Restoration Act, has not been altered in the 29 years since it's been passed. The purpose of the act was to restore a compelling interest test, to be able to make sure that if government acted in any way to affect anyone's religious liberty, there had to be a compelling reason for that from the government, to guarantee its application in all cases where free exercise of religion is substantially burdened, and provide a claim or defense for those whose religious exercise is substantially burdened by government. Religious Freedom Restoration Act doesn't pick winners and losers. It provides a balancing test. The government may burden someone's religious exercise only if the burden is in furtherance of a compelling government interest and is the least restrictive means of furthering that compelling government interest. 29 years ago today. Then today, my colleagues moved forward on a bill that instead of promoting equality for all people of all opinions, it specifically highlights areas of religious faith differences and says their opinions won't count this time. It deals with this issue of marriage. It has been a controversial issue in America, but was quite frankly, since 2015, in the Obergefell decision in the Supreme Court, there have been no cases moved in the country to deny same-sex marriage to any individual in any state across the nation. Today, my colleagues move forward on a bill to open up debate without amendment, may I add, on a bill that would certainly affect the religious liberty of countless people across the country. That's not just my opinion. Religious liberty organizations from all faiths and from all backgrounds have already been speaking out on this issue. Just in the last 24 hours, the Alliance Defending Freedom, the American Association of Christian Schools, Catholic Vote, the Center for Urban Renewal and Education, the Centennial Institute, the Christian Employers Alliance, Concerned Women for America, Eagle Forum, Ethics and Religious Liberty Commission, the Faith and Freedom Coalition, the Family Research Council, the Family Policy Alliance, the Heritage Foundation, the Liberty Council, Lifeline Children's Services, the National Religious Broadcasters, Religious Freedom Institute, the U.S. Conference of Catholic Bishops, and the Ethics and Public Policy Center have all spoken out and said, this bill that is currently on the floor of the Senate will damage religious liberty. Religious institutions are rising up, reading the text of this bill, rather than just listening to the debate of this bill, and saying, there's a problem here. Practically, what would this mean? Practically, what could this mean? I would say, first and foremost, we don't want anyone to be discriminated against in America. Anyone to be discriminated against in America. All individuals should be honored. All individuals should be able to live their lives in freedom in America. But practically, This bill puts faith-based child welfare organizations who are operating in accordance with their sincerely held religious beliefs, maybe to place children in loving families, it puts them in jeopardy. And while some of my colleagues may say, well, that's far-fetched, may I remind you, the Supreme Court has already handed down a decision in the Fulton and would remind them this is continuing to happen. Catholic Charities has been shut out of the child welfare system in Illinois, in D.C., in California, in Massachusetts already. And then this bill is coming. Let me tell you some of the problems with the bill, because I've had individuals tell me about what they say is in the bill, and then I actually pull the text of the bill out and show it to them and say, show me where that is in the bill, and their response to me typically is, well, that's the intent of the bill. Well, we don't deal with intent here in Congress. We deal with legislation and text. The words matter in this. And the words in this do not provide the level of religious liberty protections as many in this floor that have come to debate this say that is actually in this bill. Let me give you just some simple examples of this. This bill gives a private right of action for both, well, I should say, gives protections from the Attorney General to be able to file charges against an individual that shows discrimination, or a private right of action for an individual to be able to sue another individual or entity in this, unless the discrimination is for religious liberty. They are peculiarly left out. If there's discrimination against someone's religious liberty issues and their personal beliefs or their entity's beliefs, they don't get this same private right of action. So the private right of action only goes against people that have religious objections. Those religious individuals, if they are discriminated against, are on their own. They get no protections in this bill. The bill itself, I've heard individuals say, well, it has a section in it that is literally titled, No Impact on Religious Liberty and Conscience. That's the big, nice title of that section. It's Section 6 of the bill. So let me read the Section 6 of this bill to you. The first part of it, Section A, says, nothing in this act or any amendment made by this act shall be construed to diminish or abrogate a religious liberty or conscience protection otherwise available to an individual or organization under the Constitution of the United States or federal law. That has got to be the biggest no-duh statement out there. This piece of legislation doesn't overturn the Constitution, is what it says. That is an unnecessary statement on it. Of course, the Constitution stands above it. The second part of this, in Part B, says basically a rabbi, an imam, or a pastor is not compelled to perform a marriage ceremony that they're religiously opposed to. That's the whole religious liberty section of it. The whole section. First, it says it doesn't overturn the Constitution, and second, it says pastors, imams, rabbis don't have to perform religious weddings that they're personally religiously opposed to. That doesn't help. In fact, there's a qualifying feature in the middle of all this, in that section, in Section 6, which limits the individuals that would even get any kind of protections on this by saying whose principal purpose is the study, practice, or advancement of religion. Meaning, an individual would first have to prove that your principal purpose is to study, practice, or advance religion before you even got those exceptions. Why is that important? Well, I asked some of the sponsors of this bill why that particular piece of text in there, and their explanation was, well, because we didn't want to include for protections on religious liberty private individuals in their personal religious expression or private businesses that maybe the owners of that business have a personal religious belief in how they carry out their business, but they would not have religious protections because they're not principally a religious organization. So they do not get a defense. They don't get a private right of action to defend themselves. They just have to cave to the religious beliefs of this law. 29 years ago, this Congress said we were not going to impose beliefs onto people. Today, this Congress said, if you're a faith-based individual and you have a difference of conscience about marriage, too bad. You have to prove you're a principally religious organization to have an exception. An individual doesn't count. A private business is specifically excluded. In Section 7 of this bill, I've had several of the sponsors that have told me Section 7 covers everything else. Make sure it protects nonprofits, make sure it protects all of your tax-exempt status, your grants. It's all in there until you read the text. No, those words are in there, but there's two big qualifiers that are also in that section. The first of the qualifiers begins with nothing in this act shall be construed to deny or alter the benefits. Meaning, if it's in something else, that's not protected. It has to be something specifically in this act. The second thing is the very end of this. It gives a long section on this. Nothing in this act or any amendment made by this act shall be construed to deny or alter the benefit or status. It goes on to explain some of these things, and then it ends with this: provided such benefit, status, or right does not arise from a marriage. That's the qualifier. Provided such benefit, status, or right does not arise from a marriage. Now, I've handed this around and asked legal counsels, explain to me what that means. And the first response that I get is, well, that's a clear protection for individuals that are married, that if there's any right given to any other married couple, they get the same right. I was like, that makes total sense. What about for entities? Because the word entity is in this list. And that's where it gets fuzzy. Because it has this qualifier, provided such benefit, status, or right does not arise from a marriage. We don't know how that's going to be interpreted for entities. So it's left for the courts to decide in the days ahead how that's going to be interpreted. So what's been done with this? All these things have been brought up. We've had this text now for about 36 hours. It literally just got dropped on us. So for about 36 hours we've been going through, and it's not long, it's 3 pages, asking questions, how does it work, what happens with it? And several individuals have said, hey, this is a real problem for religious liberty. We should fix this. And others have said, yeah, that's a good idea. Let's make sure this is actually clear. Except, now that the debate has started, amendments have been shut out. There are no amendments. All of these gaps that I talk about for individuals, for small businesses, for individuals of conscience, for the right to be able to protect yourself if you're facing religious discrimination on this, for the limiting portions of in this act, or from explaining not arising from a marriage, what that may mean, the issue of principal purpose and not having to prove your principal purpose in a court of law is a religious issue. Everyone seems to nod their head and say, oh yeah, those are problems. Multiple members have brought amendments and said, let's fix it. And yet they're being told over and over again, no amendments. We're not going to fix it. You know what that tells me? These are not mistakes in the drafting. This was purposeful. That's what that tells me. Listen, I believe the rights of every individual should be honored. But this is not choosing to be able to protect the rights of every individual. This is saying some people are more equal than others. That's a problem. After the Obergefell decision was made, President Obama spoke to the nation. He supported the Obergefell decision from the Supreme Court. But then he said this: I know that Americans of goodwill continue to hold a wide range of views on this issue. Opposition in some cases has been based on sincere and deeply held beliefs. All of us who welcome today's news should be mindful of that fact, recognize different viewpoints, revere our deep commitment to religious freedom. Great words that seem to be on the cutting room floor today. It hasn't taken long for President Obama's statement after the Obergefell decision to say, never mind. This is fixable. But when people see the problem and the issue with it and choose to ignore it, I have to ask why. 29 years ago today, President Clinton signed into law the Religious Freedom Restoration Act. And 29 years later, Congress is saying, never mind. I find that a problem. I yield the floor.